Hello, everybody. Welcome one more time to the show with the attorney Margaret W. Wong, who has experience for over 45 years working on the immigration field and helping thousands and thousands of families every single year across the country in more than 9 cities in the United States, in Atlanta, Chicago, Columbus, Cleveland, Minneapolis, um, Memphis, Nashville, New York, and Raleigh, North Carolina, and other cities. It doesn't matter where you are at. If you are in trouble with immigration, she will find a way to help you out, even at the crossing border, even in the detention center. It doesn't matter where you are at. She will be able to help you out. So let's welcome our head attorney, Margaret W. Wong. Welcome, Ms. Wong. How are you doing today?
Thank you. I'm good.
We're thankful that we can have you back in the office and working and doing your best as usual you do to help immigrants in this country. This is a very uncertain time for some immigrants thinking about the asylum cases. Um, for example, for Indian people, are there any changes with this Patel case that was decided in the Supreme Court?
Yes, there are actually two Patel cases that's interesting. One is a Second Circuit case, one is a US Supreme Court case. Basically, what they're all saying, basically, it's very much the law as of today anyway. The whole thing is when you go to immigration court, immigration judges are not Article 3 judges. They're only federal immigration. It's like a social, a security administrative judge. It's like the tax court, stuff like. They're not Article 3. Article 3 are judges that's a life appointment, like U.S. Supreme Court, circuit courts like Sixth Circuit, it's Ohio, Kentucky, Tennessee, Michigan. These are life appointment judges, so politics doesn't influence them because they could not be fired. And U.S. District Court, but Immigration Court, both with the IJ, which is immigration judges on the immigration courts, and also in the Board of Immigration Appeals, these are just, I shouldn't say just, these are still judges, but they are not federally appointed by the President of the United States. These are like more appointed by the Attorney General's office or appointed by administrators. So what the U.S. Supreme Court say on Patel is that if it's a factual decision, the appeals court have no authority to question the trier of facts, which is the IJ, which very much is always the law of the land, the law of the land. So, for example, if it's a criminal case, you can appeal it and argue it's a criminal issue or federal issue on constitution, on due process, on not abuse of discretion is not appealable. So basically, it's very much a lawyers and judges case saying that if the IJ, the immigration judge, says that you're not credible and they don't believe you, immigration court, the appeals court cannot question the IJ and saying that, oh, but I believe you because the IJ. So the way to overcome and to handle, instead of arguing the IJ is wrong on the fact, you argue the IJ is wrong on the law. So ultimately, it doesn't change how you do appeals cases because a lot of people now are really scared on the Patel case saying, oh my gosh, so what happened when the judge doesn't believe me? It doesn't mean I'll be deported. No, you can still appeal, but the appealable process, you should use up maybe a good lawyer instead of arguing, oh, the IJ is wrong on this. You should argue, instead of saying not credible on the fact, you may want to argue the burden of proof of the non-credibility. Of course, you have to do a very good job in your brief because appeals court only approve cases on brief. That means only on writing, unless they invite you to oral argue. I'm trying to really push our lawyers to argue in front of more circuits because most circuit courts, they don't even want us to argue because they just want us to save time. So, but it's very much a lawyers and judges case, the Patel case. So I won't pay too much attention to it. I would do a very good trial preparation. I would still go to do an appeals, but you just have to be more careful. You couldn't just go to court and look stupid, you know?
Yes, and Ms. Wong, this question is related to the first one because a lot of people have been calling us to ask the same. Is it convenient now to file an asylum case if I have a weak case?
That's a very good question. That comes in for because this is an American English speaking audience. This question is a good question, applies very much to more the southern border cases. Because, for example, I came to America 3 years ago from a southern border. I'm illegal, but I really think I have a good asylum case. But under the law, it may be not as good. For example, I was abused when I was a child. Could I bring it now or no? Because right now, Biden, the reason why they're asking this is that President Biden came up with this law saying that they're shortening the whole process. So what they're saying is the adjudicator, just like the IJ, just like Patel case, that the first officer who talked to you, he will or she will decide on the asylum case, yes or no. If it's no, you should be deported. You cannot be allowed to the country. Unlike, I mean, they've been talking about this for months and months, but unlike, let's assume last week, the asylum officer interview you, and if you are deserved credible fear, then you get a bond and you can leave jail and you can come out of jail and wait in America mainland for about 1 or 2 years to see the judge. Now Biden is saying there's so many people who's coming through the southern border that regardless of how good or how bad your case is, the first officer who saw you will say yes or no. If it's yes, you come out. If it's no, you get deported. Now, that leads to the question of what happened if I've been here 2 or 3 years? Can I still file? And I may or may not have a strong case, because you don't know if you have a strong case until you file and you see the officer. What this law applies, I believe, is because now they're saying it started yesterday, they're saying it started months ago. Actually, this law has been in effect for some time already, because what it is you see some people, even though they get credible fear, they're material witness in a crime, because what they're doing at the border now is not just on people. They're also talking about drugs and guns. So, for example, I came with a group of 20 people with a coyote 2 months ago. Now they put me in jail, not because of my credible fear, but because they want me to be a material witness against the coyote, because the same coyote I saw helped other people bring in guns and drugs, or 1,000 people. So they want me to witness and testify in court against them. So we have actually a case like that, and she sat in jail for 6 months, and she actually testified, and now immigration was going to give him a bond, which is like $500, and get her out, but somehow she got deported. I think it was a mistake, but who knows, because the southern border is crazy. So to answer your question, Mr. Juan, is that if the person is inland, if she missed 1 year, the question is, should we do it now or maybe wait another 6 or 9 months? Depends on how strong the case is. But this law really doesn't apply to inland people. It really applies to people who are still waiting at the border, because the law specifically said that the first trier of fact, which is the asylum officer, because judges don't see them until they pass the first interview, what we call the credible fear or reasonable fear interview. So I think if you feel you have a strong case, I would still apply, because it doesn't matter, because because that law really doesn't apply to you, because you've lived here for more than a year already, or less than a year. Then you don't want to miss your 1 year, or if there's exceptional circumstances.
Yes, this is actually the question from this person, and she says that is from Venezuela. She says,
Absolutely apply.
okay,
Yeah,
thank you so
because
much.
you could probably have extraordinary or exceptional circumstances. Venezuela now is worse than before. So you can do change of personal or country condition, because if you had applied and get denied, then you need change of country condition. If you have never applied, then you can argue change of personal or country condition. And if it's worse, like something happened to your family 2 or 3 months ago, then you can still argue it's 1 year. There's a lot of rules applying to missing 1 year, and you're from Venezuela, it's not good. Apply.
Thank you so much, Ms. Wong. And for more information, don't forget to call. The phone number is 216-279-3984, 216-279-3984. The next question comes from Alan. Alan, I can't read your whole question. It's cutting off for some reason. So if I miss something, just let me know. It says, good morning, Ms. Wong. I have a question. I have a pending VAWA case for a year now. I received a prima facie after 2 months of filing and had biometrics done twice in October. My case was filed altogether, VAWA, green card, and work permit under C9 category, but I didn't receive my work permit. So far, almost a year later, I was expecting
Right.
at
So
least.
basically, you already get prima facie. You can also apply for a work permit under prima facie, but I don't even think you need it. What you need to do is check if your lawyer. See, a lot of us, and I do the same thing. If they already have a C8 work permit, and those days, and now it's still C8 is 2 years, C9 is only 1 year. But now C9, Biden just came out with a new rule about 3 or 4 weeks ago, saying C9 is 2 years now. So what you need to do is ask your lawyer. If not, if I were you, I would check the receipts, because you should have the Wawa is a 360. You can either get the 751 receipt or 360, because you already had the green card. Then you do 751. If you didn't have a green card, do 360. So you should check the 360 receipt, which I'm sure you have because you already got prima facie. You should check the 485 receipt. You should also check that you file 765. 765 and the C9, if 765 is filed, you should have gotten the, or at least a receipt and push for the approval. I would look at it, because I presume you don't have a perm bar because you never left and come back. But if the perm bar results from abuse, you should be able to overcome the perm bar. So I would check the receipt to see if it's filed. It could be you never filed in the C9, but if it's filed, I would also call them and email. There's a public email now, or under my account. If you open my account, there's an email that you can ask, and they're responding pretty fast. Or just call them. They're pretty good now. The calling is not as good as the email. If not, maybe ask a congressional office to help you, a senator's office or congressional, but you should get it. And I'm sorry about that.
Okay, thank you so much, Ms. Wong. And this person is adding that 765 was filed, and the only update showing is the fees were waived almost a
Wait,
year. I have all three receipts.
okay, maybe see, anytime I personally don't do fee waiver, because the government wants the money as much as we do. So it maybe is a waiver case, so they give it slower. But I would call them and maybe just file another one with a fee, because everybody wants money, and I don't know why. Because you could be under income, but since you already got the prima facie, this case should be approved prima facie, because every 6 months, something will happen. But I would push it. You should have gotten I would push it. All right. Maybe file a new one with a fee. Maybe it's a waiver, because I personally don't like waiver cases.
Thank you so much, Ms. Wong, for this answer. And don't forget that you can call the office. The phone number is 216-279-3984, 216-279-3984. Hi, this is Vimal Patel. Hi, can I apply for EU visa while my asylum case is pending? Thank you.
Absolutely, yes.
Okay, thank you so much. And just in case we don't know where you are at, the city that you are at, so please just give us a call. The phone number is 216-279-3984, 216-279-3984. Sahin is asking the next question. Can one out of status for 1 year, but now in TPS currently adjust status
No,
later through siblings visa,
no,
through brother applied 8 years ago?
no. brother sibling case, if you're from US, okay, so you're probably from India. So it's 15 years. So it's only 8 years. Number one, quota not open. Number two is even if you came legally or illegally have TP. That's weird. TPS doesn't apply. So you probably are from El Salvador. Wherever you're from, TPS current, make sure you get a parole. But parole on TPS can only apply for immigrants. So, for example, you have children over 21. If you had a parole on TPS, yes, they can apply for you, a spouse or citizen, but siblings and parents who are citizen cannot apply for you. Sorry. But it's
Okay.
only 8 years. You have to wait another 15. It's 15 less 7. I would have to wait another 8 years anyway. So maybe at that time, Biden would change the law because that's one of the cases we are pushing.
Okay. Thank you so much, Ms. Wong. And these questions are coming through YouTube. It's not
Oh,
even Facebook, it's YouTube, the questions that are coming
interesting. Yeah.
in. Yes. So
Thank
this
you.
question is in Spanish and it says, respectful and humble greetings. I am a person in a migration, a forced migration, and victim of the armed conflict in our country and narco terrorist threats. I want to leave my country with my family to the United States, but I have a criminal record in my country. What are my chances to win a case in the United States? Thank you and
Okay,
see you
let
soon.
me explain to you. I don't know what country you're from. You have two issues. Number one is how do you want to come to America? The only way to come as a student is a tourist, but normally they don't let a whole family come on that unless you came from a very rich family. So first you have to decide what kind of visa, either a tourist or student or green card, right? If you get a job offer in America, then you can do a green card. Because if you are not from India or China, which takes 9 years or 4 years respectively, then you can get a green card in about 2 years. So first decide what kind of visa could I come or should I go. Second is criminal record. Depends on what kind of criminal record. So for example, if you came from Israel and you threw stones, even though the police never charge you, never pick you up, the question is, did you ever throw stones? Of course, we always tell people to tell the truth, they threw stones. And then they will never be able to come because throwing stones at Israel means that you are throwing stones at the Palestinian conflict, the Israeli conflict. So it depends on what country you're from, what kind of criminal record you have. Is this drugs, sex with minors, same sex or different sex, under 18? Even though in your country may be legal, but in America it's bad. So anytime you have drugs, sex, or gangs, or guns, it's very difficult to come. So this is a good question, but I would first look at the visa because if it's not that serious, you can get an NIV waiver, non-immigrant visa waiver. So maybe you can come as a tourist with a waiver. But if you're receiving threats, they probably won't let you come because they're worried once you come, you apply for asylum. Because a tourist visa, student visa, immigrant visa, you're not supposed to come to America and file for asylum.
Okay, thank you so much, Ms. Wong, for this answer. And well, Ms. Wong, yesterday I had a very, very sad conversation with a lady. She was at her apartment, and she said that she saw a police car, and she said they never come on time. And I tried to say, well, they do, and she said they didn't do when I needed them. Then I started asking her what happened, and it happened that last year, about a year ago, some bad guys broke into her apartment. They did bad stuff, and they killed her child. So this lady doesn't want to do nothing because she's very sad. But is there a way that she could get a U visa through this case?
Absolutely, yes. So what's the cause of death on the death certificate of the child? Was that murder or accidental or
Yes,
drowning?
murder.
Oh,
Yes,
it is murder. So there
yeah.
should already be a police report. Even if she didn't report it, the hospital would have reported on an autopsy. Absolutely do a U visa. Oh my gosh, that's a very good case. But the child is an American citizen, correct? Because it's a child.
Yes.
Okay.
So he was born here,
Okay.
but something bad happens.
Okay, let me explain to you how to do this case. The reason why it may be a little bit of a problem, but I don't think so, is make sure whoever signed the 918B on the top left hand corner, make sure the direct victim is the woman or the man, the mother or the father. If that's the case, if she have other children back home, I don't know what country she's from, she can also protect them. But if they put the child as a victim, as a problem, because the child is an American citizen, so I would never be able to do the parents because American citizen can never get a U visa approved. So the trick, not the trick, but secret on this case, make sure the father and the mother's name is a direct victim. Make sure we don't forget, and sometimes even I forget to ask. We get so excited about a case, we felt so sad about a case. That's why we cannot be emotionally involved when you represent someone. Um, we have to make sure all his kids, he may have kids on another relationship before he married her, but if they're living partner in union, make sure they marry. So because of one U visa, you're protecting all his kids from overseas, your husband's kids overseas, you're also protecting her kids from overseas. So that's when aside from filing the U visa, they should also file for all the kids, even though they're overseas. The good news is if they are from not from Mexico, but if they're from three countries, Central America, El Salvador, Guatemala, um, and
Honduras.
Honduras. Thank you, Honduras. Then once you get a receipt, they can go to CAM, CAM program that restarted by Biden, that Obama started, but more than 20 people came. Trump took it away. If they can go to camp with this receipt, then the kids can come earlier, including step kids. And I think they also include stepmothers and stuff like that. You have to look at so this is a very good case. But the whole thing is make sure she or her husband is a direct victim, not a citizen child.
Okay, thank you so much, Miss Wong. Um, I was trying to convince her that she has a case, but she says, I am too sad. I'm not ready for this fight. I don't want to bring that to my memory because it was too bad. It was too hard for me. And well, I stopped asking questions because, you don't want to get too much in there or push it too much when people don't want to talk about something.
But that's why she may need to go see a social. And if I were her, I would go see the victim of crime services. They provide free therapist report. It's not, I know a lot of people feel guilty. I don't want to use the death of my child to help my whole family come to America or stay. But more than that, it's like, why did the baby die and not me? So people like us who do a lot. So basically, there's a gap between lawyering um, and social worker, because social worker's job is really to hold their hand and to see if there's any other help, at least give them the advice. Because when she's that depressed, she's so out of it, she's probably not even hearing or listening. Because people like us, we are alert. We say, oh, this is the case. Let's do this. For them, it's like they need someone to push them. They need a therapist, and it's hard because in today's world, everybody don't feel like working. Everybody doesn't have more love to give, because sometimes I feel the same thing. We're so tired. We have COVID, we have a cold. I'm just exhausted, and then something happened, something. So that's a problem. I wish each of us have more love to give, more time to give, and just call her and say, hey, how are you doing? Just to hold her hand. It's not so much about the visa as to she needs to get out of her grind. She needs to get out and go out and get a job, get a part-time sales job, meet people and hear other people's stories. But the more she hear, the more she's not just so in her own grief. There's nothing more sad than losing a child. It's sadder than losing a spouse, which I went through. But losing a child, especially a cute little baby, is, oh my gosh, I don't even know how they go through it.
Yes, thank you so much, Ms.
Yeah,
Wong. And yeah, losing a father, it's called
that's right.
orphan.
Yeah.
Losing a husband or wife is called widow. But losing a child, it doesn't have a name. It's not supposed to
That's
happen.
a good one, Mr. Juan. That's why you're smart. Yes, I never thought of that. And I hate the name widow. I hate it. Yeah.
Yeah. Okay, thank you so much, Ms. Wong. The phone number, don't forget, is 216-279-3984, 216-279-3984. So Sahin Shrestha is from Nepal in the
TPS.
United States, out of status for 1 year, but now on TPS since 2015. Also paroled twice in 2016 and 2019. My question is, my wife is waiting for EB3 nurse interview. How would it affect her interview since I was out of status?
Good job. So I presume your wife is on F1 or B2 because wives cannot do, nurses cannot, they don't have H1. So I wonder what your status is the wife. Let the wife get the green card first. If you don't mind keeping TPS because it's Nepal, when she becomes a citizen after 4 years and 9 months, she can apply. Then you can, because you already have 3 parole or 2 parole, you can parole in as a green card holder. But if she only have a green card, you cannot wait. Oh yes, you cannot because you have a parole now because if she has a green card, you're F2A, you can apply, but green card spouse are not allowed 180 day out of status. So your wife could have 180 day out of status. You could, but actually you have a good case. You may have a good case because you're paroled in. That means your legal entry, you never overstayed after that legal entry, but you had illegally entered, I presume, or even if you come on the you came as a student, she came as a student. Come, oh my gosh, what a smart wife! She has a master's, and I presume she's an OPT. That's good because Nepal, you have a quota open. Yeah, so she's in status. She have 485 is filed. She already have a C9. She's in status.
So, Sahin, please just call us right away if you need
That's
more
a good
help.
case because you cannot use her status because you're already out of status employment base. You're only the spouse. But if she got the green card, I wonder if you can do 45 right away because family 2A under Biden is current. Biden is thinking of making family 2A. You're current, you have a TPS, your parole. The problem is you were illegal before. So that's a good case. I have to do some research on that because green card spouse, you're allowed 0 days out of status. But before you came back on parole or before you get all these TPS Nepal, you were illegal because you came as a student on tourist, but there was a period you overstayed. But that's good because F1, you don't become overstay unless USCIS adjudicate, but you're never in court. You have a good case. That's an interesting case because you have TPS. TPS is weird. Yeah.
Okay, thank you so much, Ms. Wong. And don't forget, Sahin, that the phone number is 216-279-3984. Please just give us a call. We don't know where you are, but we can take care of your case uh, with the technology that we have nowadays. So the phone number 216-279-3984. And Ms. Wong, the last question for today is coming from Rahubai Patel. I lived in New York, in Long Island, New York. My daughter filed a
So
petition
this is a
for green
good
card.
number one. Make sure you get the I-130, 485, 765, I-131 receipt notice. Then you can go on the internet, just go on the CIS.gov and check the receipt notice of work permit and travel document. And we talked about this issue like some weeks ago in the in this program, talking about they're not giving up. They're not giving us the double. I call them the double jumbo card. They used to give you a small card saying that parole approved 1 year, work permit approved 1 year, because you should get a C9 that's approved for 2 years now. So congratulations. And you should get the Social Security number in the same mail after 30 days. And you should be approved because 270 days is like in June, right? Because now it's May. So you must have found September, October. So it should be coming pretty soon. But check that receipt, go into the internet and check it. No, this is 100% no issue because I presume you came on a tourist visa. You filed the 45 after 100 after 91 days. Under Trump, everything goes in the interview. There's a delay. Also check if your case was transferred to another place. Under Biden, you may not even need an interview. They're trying to go back to everything is legal, no problem, no interview. So congratulations. I don't see a problem in your case at all.
Okay, thank you so much, Ms. Wong. And well, we are done for today. Our time is up. It went flying. We love when you are uh, in the show because time goes really, really fast and we learn a lot from you. So thank you so much for sharing these over 45 years of experience working on this field. And please never get tired of doing what you do because you do it for love. You do it for helping people, and we know your heart to help your people, which is awesome. And thank you so much for all you do as well.
Thank you.
Thank you so much, and see you next Wednesday and Thursday here in the city of Atlanta.
Thank you.
Thank you so much. And for everybody who has joined us today, please don't forget to call the office. The phone number is 216-279-3984, 216-279-3984. The phone number you can call in any cities. And Ms. Wong has offices in 9 cities of the United States, in Atlanta, Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216-279-3984, 216-279-3984. Please get in touch with us, and she will be able to help you out. Thank you, and see you next time.